So, good afternoon, everyone. Hello. So, I'm Mohammed Haider Abbas. You're watching me on RostrumLegal. I'm back again with a bunch of issues to be discussed this week. But as part of legal awareness, we can't simply restrict our discussions to current legal topics, but also we have to discuss certain recent and landmark judgments of the Supreme Court. Judgments in the sense that we have to understand them from the perspective of the like a brief overview of the facts of the case and alongside the mm, contentions of the petitioner as well as the contentions of the respondents, and then we'll have to find out the ruling of the Supreme Court. Okay, for reading the judgment, for reading any judgment, we have to understand the title of the case, the what it is about. Second is what the case is concerned about. Third is that what kind of how the petitioners have approached the Supreme Court, like in the sense they have filed a simple writ petition or there was a public interest litigation. Okay, there was public interest litigation or what? Okay, so there is need to understand that today we have Indian Young Lawyers Association and others versus the state of Kerala and others, a very famous landmark judgment of the Supreme Court recently, which has thrilled, and has also thrilled people across the country, and has also agitated yet another debate of entry of women at certain religious places. However, this case was particularly about the entry of women in the Sabrimala Temple. Uh, okay, but this judgment of the Supreme Court has, agitated debates also for the entry of women at various other religious places, which have hitherto banned their entries at least up to the sanctum sanctorum. Okay, so Indian Young Lawyers Association and others versus the state of Kerala and others. This is one of the landmark judgments, and we are going to discuss it today. Okay, citation is 2018 SCC. Online is Supreme Court 1690. Okay, 1690. Now, introduction, like a brief overview where it's when it started and how it started. Then we are going to study the background. Okay, what actually happened, what led to the case, what led to the dispute, and how it went before the apex court of the country. Then we are going to read the contentions of the petitioners. Who are the petitioners? Who are the respondents? And then we are going to read the contentions of the petitioner. Okay. Then we are going to read the ratio descendi. Okay, we have to divide the judgment at least into two. The two broad classifications of of any judgment are the ratio descendi and the obiter dicta. So ratio descendi is basically the judgment, the binding judgment, while obiter dictum is the judge's own opinion about the issue. Okay, that is not binding. Okay, the reason behind the judgment is expressed in obiter dictum. So ratio descendi is the judgment. So we are going to read it this way because we have to divide, we have to create this kind of a structure for reading a judgment. Only then we can better understand and understand any issue regarding the judgment of the Supreme Court quite comprehensively. Okay, so this case was filed. I'm starting to read this PDF. The case was filed in 2006 by the Indian Young Lawyers Association through public interest litigation. What is public interest litigation? Public interest litigation, let me tell you very briefly, and you all must have read and you all must be knowing this. Just for the sake of satisfaction, I'm repeating it, that public interest litigation is nowhere mentioned in the original constitution. of India. Okay, if you are going to open Article 32 of the Constitution of India or Article 226 of the Constitution of India, that simply talks about filing of the 5 writ petitions in case of violation of fundamental fundamental rights. Okay. And also any legal right under Article 226, you can approach any high court. Also, you can approach Supreme Court only on the gross violation of your fundamental right under Article 32. However, you can approach any high court under Article 226 not only against the violation of any fundamental right, but also against the violation of any legal right as well. So, PIL is not something which is new to India. PIL was first, PIL actually is an innovation of the Supreme Court. The Supreme Court in 1970s, like they introduced this public interest litigation, and actually this concept was borrowed from the America. Okay, that if one particular person faces a violation of fundamental right, then he can file a writ petition before the Supreme Court under Article 32 of the Constitution of India. Okay, under Article 32 he can simply file a writ petition and he alone being a petitioner. But what if one single cause becomes the reason for violation of fundamental rights of a large number of people? What do you think, that every single individual out of that group should approach the Supreme Court separately or independently, or this entire group should together approach the Supreme Court? So exactly what is what P exactly here the PIL comes into picture. The public interest litigation is that when one single cause becomes the reason for the violation of fundamental rights of all the citizens, or for example for a large group or large number of people, then every single person out of that group should not approach the Supreme Court independently, but they should file a public interest litigation together being the petitioners. Also, there is one more concept called proxy interest litigation. Proxy is when you do something on behalf of another, that is known as proxy. So this proxy interest litigation is that when the various social organizations or who are indulged in various social works, they are fighting and they are working for the benefit, like for the community people. They are working for the benefit of the poor. They are helping them get justice. So you must have come across like the way in this case Indian Young Lawyers Association came forward and what is filed a PIL before the Supreme Court. What is this? This is known as proxy interest litigation. That the NGO, for example, is not itself the aggrieved party, but the aggrieved party happen to be a community of people who are downtrodden, who cannot approach the Supreme Court. So the NGO is taking up the issue, and on behalf of them, it is filing a PIL, and this is known as proxy interest litigation. Okay. So the case was filed in 2006 by the Indian Young Lawyers Association through public interest litigation before the Honorable Supreme Court of India. The case deals with an important aspect, that is entry of women in Sabrimala Temple. Now, this Sabrimala Temple is the entry of women in Sabrimala Temple is the biggest issue. There were many issues raised in which it was argued by petitioners that provisions related to the restriction of the women entry in temple are unconstitutional as it violates Article 14, 15, 17, 25, 26 of the Indian Constitution. The Sabrimala temple is situated in the Periyar Tiger Reserve in the Western Ghat mountain ranges of Pathanamthitta district of Kerala. Now, this temple is famous for Lord Ayyappa. Okay, it forbids the entry of women in their menstruating age that are between the age of 10 to 50 years, stated that it is a place of worship. Okay, so this case was filed in 2006 by the Indian Young Lawyers Association through a public interest litigation before the Honorable Supreme Court of India. The case deals with an important aspect, that is entry of women in Sabrimala temple. Sorry. There were many issues raised in which it was argued by petitioners that provisions related to the restriction of the women entry in temple are unconstitutional as it violates Article 14, 15, 17, 25, and 26 of the Indian Constitution. The Sabrimala temple is situated where? It is in the Periyar Tiger Reserve. There is a river Periyar in Kerala, and there is also a tiger reserve named after this river Periyar in the Western Ghats mountain ranges of Pathanamthitta district of Kerala. Now, this Western Ghat, this stretches across six states, like from Gujarat up to Kerala. Okay, and they are high peaked mountains running across the across the coastal areas, like coastal length of the country, spreading across six states. So it reaches up to Kerala. This Western Ghat range stretches up to Kerala, and there is a Periyar Tiger Reserve in the Western Ghats also. Then there is a Pathanamthitta district which in the state of Kerala, situated in the Western Ghat mountain ranges. Okay, so there is a very famous temple called the Sabrimala Temple. Now, this temple belongs to which deity? This temple belongs to Lord Ayyappa. Lord Ayyappa Lord Ayyappa is a deity who happens to be virgin. He is virgin, and uh, it forbids the entry. And therefore, keeping his keeping and taking considering his piousness and his holiness, and keeping in mind his virginity, it forbids the entry of women in their menstruating age that are between the age of 10 to 50 years, stated that it is a place of worship, because this sort of menstruation is considered unpious and unholy, and therefore women, girls especially who are menstruating between 10 to 50 years, they have been strictly prohibited from entering the temple in order to keep the piousness, maintain the piousness of the temple and also the Lord Ayyappa. Background. Now, let us understand the background. The Sabrimala temple is one of the most well known pilgrimages of Hindus. We have a sort of lot of various religious places in India, which are very famous pilgrimage places. Okay, like Shirdi. Okay, we have so many places in Gujarat. Okay, so Sabrimala is also one of them. The Sabrimala temple is one of the most well-known pilgrimages places of Hindus. The Sabrimala shrine, which is one of the most famous temples in Kerala, had restricted women of menstruating age from entry. Several women tried to enter the temple but could not because of threats of physical assault against them. In 1991, a group of five women lawyers had moved to the apex court challenging the decision of the Kerala High Court. Okay. Now, this is written very bluntly and very in a simple language, that the Sabrimala shrine, which is one of the most famous temples in Kerala, had restricted women of menstruating age from entry. This was the rule. Okay. Several women tried to enter the temple but could not because of threats of physical assault against them. We all know that people are very particular about their customs and practices, especially religious customs and practices. So they become like they lose all their coolness and temper while dealing with these kinds of things. When several more women tried to enter the temple, uh, they were not, they faced some physical assaults against them. So in 1991, a group of five women lawyers had moved to the apex court challenging the decision of the Kerala High Court. The court gave judgment in favor of the prohibitory and said that these restrictions are not discrimination to the constitution. Okay, a group of five women lawyers, they moved to the apex court challenging the decision of the Kerala High Court. The court gave judgment in favor of the prohibitory and said that these restrictions are not discrimination to the constitution. In 2006, the ban was opposed by the Young Lawyers Association, appealing that Rule 3B of Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965 states that women who are not by custom and usage allowed to enter a place of public worship Later in 2008, the PIL was heard by a constitutional bench, including the former Chief Justice of India, Deepak Mishra. So, in 2006, the ban was opposed. Earlier, the Supreme Court, upheld what the Kerala High Court had already observed, that these kinds of prohibitions are not discrimination, because uh, these kinds of practices and customs have been in practice since a very long time, and you cannot say this to be because men do not men are not subject to, they do not undergo menstruation. Okay, so this prohibition would have come for them had this had this natural phenomenon would have occurred in their bodies also, biologically, but that does not happen. Okay, so if women are subject to such kind of thing, then they must also be prohibited from entering the temple. Then in 2006, the ban was opposed by the Young Lawyers Association, appealing that Rule 3B of Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965. See, this religion is a state subject, and so every state has legislated their own laws and practices, giving legal touches to various customs and usages which have been in practice for so long. So exactly that, the Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965 states that women who are not by custom and usage allowed to enter a place of public worship. Later in 2008, the PIL was heard by a constitutional bench, including the former Chief Justice of India, Deepak Mishra. Okay. Later on, in 2006, the ban was opposed by the Young Lawyers Association, appealing that Rule 3B of Kerala Hindu Places of Public Worship, Authorization of Entry Rules 1965, states that women who are not by custom and usage allowed to enter a place of public worship. Later in 2008, the PIL was heard by a constitutional bench, including the former Chief Justice of India, Deepak Mishra. Now, who are the petitioners? First is the Indian Young Lawyers Association. Second is Dr. Lakshmi Shastri. Third is Prerna Kumari, then Alka Sharma, and Sudha Pal. These are the names of the petitioners. Okay, respondents. Who are respondents? The state of Kerala, Travancore Devasam Board, Chief Tantrik, like who is the priest, the chief priest, the chief tantri of Sabrimala Temple, District Magistrate of Pathanamthitta, Nair Service Society, Akhil Bharatiya Ayyappa Seva Sangham, Ayyappa Seva Samiti, Ayyappa Puja Samiti, Kerala Kshetra Smarak Shan Samiti, Pandalam Kottaram Nirvahaka Sangam, Sabrimala Custom Protection Forum. Now, these are very typical names, like very typical South Indian names, and it was a challenge for me to pronounce them correctly, and I did it. So, the state of Kerala was this the first respondent in this. Then there is Travancore Devasam Board, then the chief tantrik of Sabrimala Temple, the district magistrate of Pathanamthitta. You can read all these names and you can understand these are the respondents, because they were all made the party by these petitioners, because they had some or the other participation of their participation in the management and administration of the Sabrimala Temple. Okay, now comes the issues before the court. These are very important points. What are the issues before the court? Like the way we have read in the evidence law, what is an issue? Like, okay, and what is, like, sorry, in CPC and CRPC, we read how the charges are framed, how the issues are framed. Okay, issues before the court. So, whether the uh, what are the issues before the court? What questions were supposed to be decided by the Supreme Court? Whether the exclusionary practice, which is based upon a biological factor exclusive to the female gender, amounts to discrimination and thereby violates the very core of Article 14, 15, and 17, and protected by morality as used in Article 25 and Article 26, 6 of the Constitution. Okay. See, understand the nature of the question, what the question is trying to portray. what the Supreme Court is trying to decide. The thing is whether the exclusionary practice, okay, exclusionary practice is that there is a biological factor which is exclusive to the female gender, and based on that biological factor, an exclusionary practice has been designed and has been given the color of law, and is being practiced openly while prohibiting women from entering into the temple, inside the temple. Okay, whether this kind of practice amounts to discrimination and it violates the very core of Article 14, 15, and 17, because Article 14 would no wonder if it protects such prohibitions because of the doctrine of reasonable classification. We have come across the doctrine of reasonable classification, and even one person, according to the Supreme Court, even if one person happens to be a different person from the rest of the society, then this person may become a reasonable classification, can constitute a different class. This one person can also constitute a different class, and there might be some different rules for him. Okay, Article 15 is again prohibition of discrimination on certain grounds, including sex. So this raises a blatant question of how, if this discrimination is based solely on the basis of gender, how then Article 15 cannot be invoked. Article 17, prohibition of untouchability. Untouchability is a practice which is not solely confined to the like this like we have a number of classes who have faced this horrible kind of thing called, despicable kind of thing called untouchability. Untouchability may be any practice, any practice of untouchability, and this can be a practice against anyone, like the way women have been prohibited from entering the temple because there's a sort of untouchability. People do not want them to touch and enter and get in touch with the other person. So this is also a sort of untouchability. You cannot restrict this untouchability phenomenon um, only to a certain classes or communities or tribes in the country. Okay, and whether this kind of practice is violates Article 14, 15, and 17 of the Constitution. Okay, then whether this morality, the word morality used in Article 25, what is the word morality? Morality is how, by what words, what are the opening words of Article 25? Subject to public order, health, and morality. These are the three grounds based on which any state can restrict your freedom of religion. If your religious practice is hampering public order or is compromising with the general health of the community or the society, or if it happens to be immoral and is setting immoral precedents in the society, then definitely the state has the power to restrict your freedom of religion and restrict your religious practices or customs. Same under Article 26, Clause 6 of the Constitution. So the question was that these kinds of words, if they are contained in these articles, Article 25 and 26, then whether this practice is protected by this morality or not. Second issue, whether this restriction violates the provisions of Kerala Hindu Place of Public Worship Act of 1965. Okay, whether this Kerala Hindu Place of Public Worship Act 1965 has contained certain religious rights and religious freedoms. So whether this restriction violates the provisions of Kerala Hindu Places of Public Worship Act 1965. Okay, then whether the Sabrimala Temple has a denominational character. This issue actually arose during the debates and during the contentions of the petitioners as well as the respondents, that if this temple happens to have a denominational character, then they can evolve any practice in order to make sure that their customs, their beliefs are protected especially of the ones of the community or the denomination they belong to. Then, whether Rule 3 of the Kerala Hindu Places of Public Worship Authorization of Entry rules permits religious denomination to ban entry of women between the age of 10 to 50 years. Okay, rules permits religious denomination to ban entry of women between the age of 10 to 50 years. Now, arguments by the parties on the issue. Let's read the arguments by the parties on issues. Arguments in favor of women entry. Okay, arguments in favor of women entry. The arguments given in favor of women entry by the petitioners were menstruation is not impure and that women should have equal rights to enter in the Sabrimala Temple. Now, this is something which is very difficult to be decided by the Supreme Court, because the question of purity and impurity, holiness or unholiness, pious or unpious, these kinds of things are not to be these kinds of things are not worldly. They are not worldly things. For you something might be hygienic, but the same thing cannot be pure for you. You might not consider that thing holy or pious. Okay, being hygienic, being neat and clean is different, but being pious and being pure is a different question altogether. So, whether the menstruation is pure or not, this is something which differs from person to person. Every religion has laid down certain guidelines for this. So, however, still, the petitioners were trying to prove that menstruation is not impure and that women should have equal rights to enter in the Sabrimala temple. Okay. Then, in our society, since ages, women had to struggle or fight for their equal position at public platforms. It is not about the representation, but is also about the ideological fight with the rules and customs and patriarchal society, according to which women remain subordinates. This case has been fought against the patriarchal philosophy of the religious order which prohibits the entry of women into the temple. The case provided the Supreme Court with a chance to balance the gap between constitutional ideals and social reality. Okay, so this is an ideological fight. The petitioners are trying to say that this is not just about Section 3B of the Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965. This should not be looked upon only by only from the legal angles. Okay, this should be looked upon in while keeping it in the background of what women have been facing since ages. Women have been struggling against the patriarchal status quo in the society, and they are trying to make their own places in the society, and they have been considered subordinate to men only because of these kinds of biological factors since ages. They were subject to torture and absolutely baseless and nonsense victimization only because they have to face these kinds of biological phenomenons like menstruation. So this is not only a fight only for the entry of women in the temple, but it is also a fight against the patriarchal mindset. Okay, against a mindset that considers menstruation as impure, against a mindset which considers women subordinate to men, against a mindset that women should be subject to torture and utter victimization while they're menstruating. So this is a fight against this mindset. So the case was brought not only with legal arguments but also the sociological aspects involved relating to the status of women in society, especially Indian society. The case provided the Supreme Court with a chance to balance the gap between the constitutional ideals and social reality. Article 14 in the Constitution of India 1949 states equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Okay, within the territory of India. Then it contains two phrases equal protection of law and equality before the law. Equality before the law is a very simple phrase and a very easy phenomenon to be understood within seconds. What is this? That every person, right from the president of India to a rickshaw puller in this country, everybody is equal before law. Nobody is above law. Every citizen is subject to the same law, and there should not be anything above the law. It's a rule of law, equality before the law. Okay, or the equal protection of the laws, or the equal protection of the laws. What is equal protection of the laws? Equal protection of laws is that if certain privileges are granted to a class of people in the community, obviously all are not same. Every community, every person has a different demand. Okay, and they need a different treatment. So certain communities were granted certain privileges. Okay, like for example, the SCs, STs, and OBCs were given reservation. Okay, but the upper class could not claim it and cannot claim it because their position in the society was far better than the position of SCs, STs, and OBCs. If a privilege was being granted backed by law to the SCs, STs, and OBCs, this simply means that they are not, like, they are being given a platform to grow themselves and come at power with the other classes, with the other community. Okay, so this is known as equal protection of laws. This is not against the principles of equality under Article 14. Similarly, Article 25, freedom of conscience and free profession, practice and propagation of religion. Like you have freedom of conscience, you have freedom, free profession, practice and propagation of religion. Okay, all persons are equally entitled to freedom of conscience and and the right freely to profess, practice, and propagate religion. Article 15 is prohibition of discrimination on grounds of religious, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, and place of birth. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. Okay, so this can't be simpler. The rule can't be simpler. It simply says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, and place of birth. So this is a sheer discrimination based on sex. Second is that no citizen shall, on grounds only of religious, race, caste, sex, place of birth, or any of them, be subject to any disability or liability or restriction or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. That means any public place can be freely visited by any person in this country. Does not matter which community he belongs to, which religion he belongs to, okay, which gender he belongs to. Because right now it's not solely about the male and female, it's also about the third gender. We have also entered an era uh, where the rights of the transgenders have also been recognized. So you cannot disable a person. Okay, women in this age, this from 10 to 50 years of women, have been openly disabled. Okay, they have been restricted. See, here is a Disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. Okay. Article 17, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Okay, so untouchability is abolished and its practice in any form is forbidden. Okay, the enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. If you are practicing any and inscribing any inability to anybody based on untouchability, just because you don't want to touch him or her, you don't want him to come near you, only because you can consider him or her as unpious, this is known as untouchability, and this practice is punishable in accordance with law. Okay, this is not solely restricted to some communities in India, but this has been practiced for so long also against certain women, like the way it is being done in the Sabrimala temple. What is the law? This is the protection of the enforcement of any disability arising out of untouchability an shall be an offense punishable in accordance with law. So, simply if you are going to practice untouchability against any person, be it a man or a woman or any person belonging to any community, only because she's a woman, or he belongs to a particular community, this is untouchability and this is punishable in accordance with law. Okay. What is the law? Protection of Civil Rights Act 1955. Okay. Article 26. Freedom to manage religious affairs subject to. Now, what does Article 26 says? Freedom to manage religious affairs subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right shall have the right to manage its own religious affairs. Okay, to manage its own religious affairs. Now, this is subject to public order, morality, and health. Public order, morality, and health again. And they have the freedom to manage their religious affairs. So, this raises a question that if they have the freedom to manage their religious affairs according to their own beliefs, and they have the right to decide the parameters for morality also, then this question comes into picture that every religious denomination like Sabrimala or any section thereof shall have the right to manage their religious affairs. The provision in Kerala Hindu Place of Public Worship Act 1956, which support restriction to women's entry in the temple, is unconstitutional as it violates Article 14, 15, 25, and 26 of Indian Constitution. Okay. Kerala Hindu Place of Public Worship Act 1956, which support restriction to women's entry in the temple, is unconstitutional because this act supports restriction to women's entry in the temple. And hence, this is unconstitutional. These are the arguments by the petitioners. Okay. In the temple is unconstitutional as it violates Article 14, 15, 25, and 26 of the Indian Constitution. One of the arguments from the side of the petitioner that Lord Ayyappa temple was not separate religious practice performed in Sabrimala temple at the time of puja, and other religious ceremonies are not different from other religious practices performed in other Hindu temples. Why, if other Hindu temples are not restricting menstruating women, then why should Sabrimala temple be alone the one to restrict women's entry into the temple? Because जो पूजा वहां पर हो रही है वही पूजा बाकी हिंदू temples में हो रही है, है ना? जो चीजें साबरीमाला टेम्पल में हो रही हैं वही बाकी टेम्पल्स में भी हो रही हैं। तो जब कोई डिफरेंस नहीं है, तो why should not the menstruating women be also allowed to enter the temple? Then argument against women entry. The arguments given against women entry by respondents, such religious practices are not as old as it is a tradition to respect God, goddess of temple. Men are also restricted to entry and worship in several temples, for example, Brahma temple or Pushkar. Okay. Now, these are the arguments by the side of the respondents. Okay. The arguments given against women entry by respondents, such religious practices are not as old as it is a tradition to respect God, goddess of a temple. They say that there is a difference between temples also. Okay, because different temples, they belong to different deities or different gods or goddesses. Okay, and every god and goddess has a different set of parameters for deciding morality and immorality. Lord Ayyappa is a virgin deity. Okay, and so a special care has to be taken to make sure that menstruating women do not enter the temple. Men are also restricted to entry and worship in several temples. There are also several temples in India where men have been restricted to entry and worship. Okay, it's not alone that women only are being subject to such restrictions, but men are also restricted to entry and worship in several temples. For example, Brahma temple and Pushkar temple. Why always a restriction on women becomes an issue? Why not always, why not sometimes at least, a restriction on men should also become an issue? Okay, why it did not bother these petitioners to also take into account the restriction and sort of discrimination against men in the country at various temples or at various other places, right? So there is no violation of Article 15, 25, and 26 of the Indian Constitution, as the restriction is only in respect of women of a particular age group and not women as a class. Okay, we are not discriminating against a class. Although you may call it a class within a class. A class, women as a class on the whole, and then 10 to 50 years of women out of the whole community of women, 10 to 50 years aged women. This is the class within a class. Okay. But they say that this restriction is like that this restriction uh, is not against a class. This is only in respect of women of a particular age group. Okay. We are not restricting women. We are not restricting women. Make sure that you understand this. Petitioners were saying that why women should be subject to such restrictions. Why women should be restricted to such restrictions? Why not why not men? Now the respondents are answering this question, that we are not restricting women as a class. We are not discriminating on the basis of sex. We are simply, women are most welcome. Girls below 10 years, women above 50 years are most welcome. And they usually come. But, but this is only about women of a particular age group and not women as a class. Okay. Therefore, the provisions in Kerala Hindu Place of Public Worship Act 1965 also support this restriction. Also support this restriction. So these were the arguments by the respondents. Okay, these were the arguments by the respondents. Okay, so if you have understood these things, make sure that you may ask questions, because if you have any doubt regarding the contentions of the petitioner or contentions of the respondents, you may ask. Because after this, we are heading towards the judgment. Any question? No questions? Okay. So now I am moving on to the judgment, the main thing, the main part. What the Supreme Court observed. See, there are two broad classifications of a judgment. You can divide the judgment into two parts. One is ratio discendi. One is ratio discendi. Ratio discendi is the rule of law on which judicial decision is based. It is legally binding. Ratio discendi is the rule of law on which judicial decision is based. It is legally binding. Okay, the majority ratio, okay, of a bench is the rule of law, and it becomes a decision, and this decision is a judicial decision, and this decision is legally binding. Okay, on 28th September 2018, the court delivered its verdict in this case by 4 is to 1 majority. Look at the ratio. This ratio is important sometimes. On 28th September 2018, the court delivered its verdict in this case by 4 is to 1 majority, which held that the practice violated the fundamental rights to equality, liberty, and freedom of religion. Article 14, 15, 19, Clause 1, 21, and 25, Clause 1. Okay. So the Supreme Court said that, and by 4 is to 1 majority, the ratio is also quite you know quite important. 4 is to 1, like just one judge dissenting, the other judges, the other four judges held that the practice violated the fundamental rights to equality, liberty, and freedom of religion. What about the equality? Why should a class of women, only a class of women from 10 to 50 years of age, should be subject to such restrictions? So, this is a sheer violation of equality. Then they do not have liberty. They also do not have liberty and freedom of religion. They want to visit Lord Ayyapa's temple. They want to pray there. They want to express their, जिसको उर्दू में कहते हैं खराज अकीदत पेश करना, है ना? They want to express their love and devotion to Lord Ayyappa. Why should they be restricted then? Okay, so which held that the practice violated the fundamental rights to equality, liberty, and freedom of religion. Article 14, 15, 14 is violated because this is a sheer violation of equality. 15 is violated because this is a sheer and open discrimination on grounds of sex. Then third is it's a freedom of speech and expression. Okay, every citizen shall have the right to freedom of speech and expression. If you are not allowed to speak, and if you are not allowed to express, and if you are being restricted from doing this, then this is a sheer violation of article 19(1) also. Okay, 19.1 also. You have a bunch of rights from A to F. Like Article 19 Clause 1 contains six rights from A to F. Okay. So you have right to freedom of speech and expression. Then you have right to assemble peaceably without arms. Then there's a long list. So you have the right to freely travel and settle in any part of India. Okay. And you have the freedom to visit any place. So these are all like your freedoms contained under Article 19 Clause 1. Then 21, personal life and personal liberty. Okay, right to life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Okay, except according to the procedure established by law. Right? Then comes Article 25, Clause 1, which gives every citizen the right to freedom of religion. So the Supreme Court said that this is a sheer violation of Article 14, 15, 19, Clause 1, 21, and 25, Clause 1. It is struck down Rule 3B of the Kerala Hindu Places of Public Worship Act as unconstitutional. Rule 3B allowed for Hindu denominations to exclude women from public places of worship if the exclusion was based on custom. If the exclusion was based on custom. Rule 3B allowed for Hindu denominations to exclude women from places of public worship if the exclusion was based on custom. The Apex Code has allowed entry of women of all age groups to the Sabrimala Temple and held that devotion cannot be subjected to gender discrimination. Devotion, it's like it comes from the heart, okay, and it has to be respected, okay, and it cannot be subjected to gender discrimination. Okay, so the Apex Court has allowed entry of women of all age groups to the Sabrimala temple and held that devotion cannot be subjected to gender discrimination. Okay, then, obiter dictum. Obiter dictum is a judge's expression. Like we have read ratio decidendi, now we are going to understand obiter dictum. Obiter dictum is a judge's expression of opinion uttered in court or in written judgment, but not essential to the decision and therefore not legally binding as a precedent. In this case, the court ruled thus. We have no doubt in saying that such practices infringe the right of women to enter a temple and freely practice Hindu religion. Okay, इसमें कोई भी शक की बात नहीं है कि ऐसी जो प्रैक्टिसेस हैं वो women rights को infringe कर रही हैं to enter a temple and freely practice Hindu religion. ये ऑबिटर दिखता है, ये जजेस अपने विचार व्यक्त कर रहे हैं, they are expressing their opinions. Since every one of them is opinionated, so everyone has the right to express his or her opinion. So judges also express their opinions, that we have no doubt in saying that such practices infringe the right of women to enter a temple and freely practice Hindu religion. Devotion cannot be subjected to gender discrimination. Okay? Devotion cannot be subjected to gender discrimination. Honorable Chief Justice of India stated in his judgment that religion is way of life linked to the dignity of an individual, and patriarchal practices based on the exclusion of one gender in favor of another could not be allowed to infringe upon the fundamental freedom to practice and profess one's religion. The Apex Court has declared that the practice of restricting women of a specific age group in their menstruating years from Sabrimala temple is unconstitutional. Current status of the case, there are review petitions filed challenging the judgment pending. Now the conclusion. Freedoms related to religion are essential elements for the functioning of democracy in a country like India. As we know, constitutional ideals and social reality are very different as much as possible for the smooth and proper functioning of society. We all know we have a bunch of constitutional ideals, but all of them are very different from the social reality. Our constitutional ideals talk about equality, liberty, equality, fraternity, while what we have is what is the social reality? It is in a stark contrast with the constitutional ideals. We do not have equality as it should have been there. We do not have liberty in certain cases. We do not have fraternity amongst the amongst the individuals of the community, individuals of the Indian society. We do not have it. We do not have fraternity. So social reality is very different, while constitutional ideals are actually exactly opposite to the social reality. So they're very different, but we should, try to like bring social reality to much closer to the constitutional ideals. Okay, in the case of Indian Young Lawyers Association versus the state of Kerala and others, Apex Court has tried to bridge the gap between constitutional ideals and social reality. Okay, and social reality. Now, this judgment is complete. Let us now take up questions. If you have questions, you are most welcome to ask. Any questions, students? What did the courts, Prableen is asking, what did the courts say regarding morality under Article 26? Morality has come twice, one under Article 25 and exactly in the same language under Article 26. It starts like subject to public order, health and morality. Morality. I would be discussing this issue of morality in the next week, because morality is something which does not have any rigid definition. Okay, it does not have any rigid definition. It is simply like differs from person to person. What is moral for you might not be moral for me. What you might consider immoral, I may consider the same thing as moral. So morality differs from person to person. There are no fixed parameters. There are no fixed uh, guidelines or definition or concrete definition to define and understand what exactly constitutes morality. In this case, the Supreme Court did not say much about morality. It simply said that this is a sheer discrimination, and morality is obviously this is immoral. You cannot restrict a class of women from entering the temple. This is immoral. Okay. However, earlier the same court did not consider this immoral. But now, when the PIL was filed by Indian Young Lawyers Association, the same court considered it as immoral. Okay, the standards and understanding relating to the morality, it changes from time to time. Any other question? So I am now ending the stream. Hope to see you tomorrow. Stay fine, stay safe, and do good. All the best. Bye bye. See you tomorrow.